Hi guys, we are the Truth Bombers. Truth Bombers is a podcast that seeks to educate, dissect, discuss and break down the law specifically in the areas of freedom of expression, freedom of the media, access to information, and information and technology law. This podcast is brought to you by Media Lawyers Association of Kenya, and we are here with the President of the Media Lawyers Association of Kenya. I will allow him to introduce himself.
Thank you. My name is Ibrahim Oduor. I'm an advocate of the High Court of Kenya. And by God's grace, I'm the President of the Media Law Association of Kenya. Basically, Media Law Association of Kenya is a caucus of lawyers, legal scholars, juries, and human rights defenders who have got an interest in protecting, promoting, advancing, and basically having a discourse with regards to an open civic space. And we are now 2 or 3 years old, and we seek to ensure that the public and the media space is advanced and protected, and that it is vibrant and is able to hold the powers that be to account. And I look forward to having a vibrant discussion for today's topic.
My name is Margaret. I am a second-year student at the Kenyatta University School of Law, and we are joined by my colleagues. I'll allow them to introduce themselves.
All right, my name is Margaret Achieng Aimba, and I'm also a mentee at the Media Lawyers Association of Kenya, as well as a second-year student at Kenyatta University School of Law.
Thank you very much. My name is Floyd Okelo. I'm a student of law at Kenyatta University School of Law Parklands campus. I'm also a member of the Media Lawyers Association of Kenya, whereby I also sit and chair the training committee. I'm also a certified mediator, seeking to be certified by the High Court of Kenya. Thank you.
It is worth mentioning that I am also a mentee at the Media Lawyers Association of Kenya. And now I think we can get into what we are about to discuss. So Margaret, kindly brief us.
All right, in today's podcast, we are focusing on how Kenyan courts have balanced the freedom of expression and the right to reputation, and in regard to the context of the media. And our podcast today will majorly focus on the Mogeni's case, which tested the press freedom under the Constitution as well as the Defamation Act.
Very aptly expressed. Defamation is a false statement that harms the reputation of a person. It is a statement that has been published to a third party and may or may not be made with malice. Floyd, kindly give us the specifics of this case.
The Mogeni case is a case about a 2021 case about Senator Erick Okongo Mogeni and the wife who is Lady Justice Jacqueline Mogeni. And in this particular case, it's a case of interest because in this particular case, the Nation Media Group published a report, and what they published about was about the title of what was published was about Lawmaker. That was the title, actually, in quotes, that Lawmaker pushes for the hiring of a judge. So in this case, the claimants, who is Lady Justice Jacqueline Mogeni, and of course the lawmaker, who is a senator, Erick Mogeni Okongo, were not pleased, and they felt that the statements were very defamatory from the Nation Media Group. So in that case, they sued Nation Media Group of defamation. That was in 2022. The statement was made in 2021. Then they sued, and the case was filed in 2022. That is civil appeals case number E192 of 2022. Yeah. So that is the case that today we'll be dissecting and looking into it to have a broader perspective on that particular case.
Yeah, and also it is also worth mentioning that the damages awarded for this specific case were worth 6.5 million Kenyan shillings. So, Wakili, kindly take us through defamation and how these cases are approached in Kenyan courts.
Yeah, probably, I think, just begin by touching more about this case that we are looking at. That is the case of Erick Okongo Mogeni, Senator, and Jacqueline Mogeni versus the Nation Media Group. So, of interest here is that the Nation Media Group, as Floyd has said, published what would have ordinarily been viewed as a public interest matter. So this was the context. Lady Justice Jacqueline Mogeni is currently a judge of the High Court. So she was recruited by the JSC at a point. So the article that offended them, the plaintiffs in this case, alleged that her appointment by the JSC had been influenced by the senator. Remember, the Senator one is an advocate of the High Court, a senior counsel. He is also a senator, that is a legislator. He also sits in the JLAC committee, JLAC, that is the Justice and Legal Affairs Committee. So the contention of the article was that the senator used his position to influence JSC to appoint his wife. Remember, Justice Okongo Mogeni and Lady Honorable Okongo Mogeni, and Lady Justice Jacqueline Mogeni are spouses. So at the time, Lady Justice had been the CEO of the Council of Governors. So an interesting part of it, of the argument there was that rather an interest part of the allegations was that the justice had not really practiced law, so that her appointment to the bench could only have been influenced by her husband, who is a very powerful person, by all means. Yes. Yeah. Remember, right now, I think he holds another position. Is it the minority deputy whip or something in the Senate? I will confirm that, but yeah. So the other interest aspect of it that you wish to notice that they did not mention them by name.
Yes. It was innuendo.
Yeah.
That's true.
Yeah. So they didn't mention them by name. So they just published an article saying that the appointment of a certain candidate has been influenced by her husband, who is a powerful. So they gave all the descriptions that would point to the senator, and that was at the crux of the senator's claim. That's the senator and the judge. That as much as they were not mentioned by name, the entire description could only point towards them. Yeah, and it's a case that I would really invite our readers to take a look at. Probably, I think it's worth giving a citation of it. It's the civil suit number E192 of 2022. Erick Okongo Mogeni and Honorable Lady Justice Jacqueline Mogeni versus Nation Media Group Limited and Mutuma Matthew. So it's the facts are quite interesting, and probably when we are discussing further, we'll look at different ways in which defamation is looked at. So ordinarily, defamation would be a direct publication against somebody, which is number one, false. Number two, it is either malicious or reckless, and that number, yes, or negligent, and that lowers reputation
in the eyes of respected society.
Yes, in the eyes of in the eyes of the society. So ordinarily how defamation occurs, it would be like, I say, let me take, use Floyd for example. I say something that is false against Floyd, and the reason why I'm saying it is malicious, or if it's not really malicious, then it is reckless. That is, by recklessness, it means that I have not taken time to verify the facts, I've not taken time to give him time to react to what I'm just about to publish, and basically taking all factors into consideration, it shows that I didn't have any due regard to his own welfare as a person and his
Reputation.
and his reputation. And so as a result of that, his reputation and standing in the eyes of ordinary men in the society has been lowered. And probably, you're going to ask me, how do you determine that somebody's reputation has been lowered in the eyes of,
You listen to what people are saying.
What are the scales of now telling this is the ordinary person and actually sane person in the society? There's the aspect of being sane.
Yeah.
Whereby, so what is the measure?
So probably, in that regard, allow me to throw this question to you, because now your students probably, you have heard this. What is the legal definition of an ordinary man in the society?
I think it is a person who is participating in society. That's what I would say.
And
Floyd,
okay.
what's an ordinary man? Because, the definition here is if your reputation is lowered in the eyes of an ordinary man. And remember, in law, all the tests, objective is usually what an ordinary man would perceive.
Yeah.
If you have done the law of tort, probably you have dealt with that. So normally the test is that of an ordinary man. It's that of an ordinary
Or
man.
a reasonable person.
Yes.
Reasonable
Yes.
person.
Yeah. Probably you remember the Lord Denning's definition of an ordinary man. The ordinary man in the Clapham omnibus. Yeah, we'll get there. We'll get there. One day in this show, we are going to discuss the ordinary man in the Clapham omnibus and why that man is very, very important in in legal discourse. So essentially, what the law looks at is that basically anybody who received this information, if they, in the context of defamation, if that person viewed you with some measure of respect, if they viewed you with some measure of integrity, then if they hear that news or item about you, they would view you different.
Okay.
And so that is the test that is that is administered by the courts. And so it doesn't have to take any special person, a huge person. It's just if Margaret views Floyd to be a person who is respectable, who has integrity, who would not interfere with processes, and if then Margaret hears that this is something that Floyd has done, she would be like, I would look at him differently. So that is the test that is administered. So back to where we started with regards to definition of defamation. So again, it is a false statement made maliciously or recklessly and has had the injurious effect of lowering the reputation of that person in the eyes of ordinary men.
So, I have a question for you, Akim.
Yes, sure.
In the case of now a court of law or
Yeah.
a court system, whereby maybe the plaintiff has already claimed a defamatory, is claiming now seeking remedy for defamation. In this case, now that we're talking about the reasonable man at the now society level. Now the question is the reasonable man a witness? Will he give a witness statement in this case, or will he appear and say, as a reasonable man, I feel like my view of Mogeni in this case, I viewed him this way, and now after the case or after what has been said by Nation about him now, I view him differently because now where does the court now draw the line to know that some group in the society felt like that Mogeni they have started seeing Mogeni differently. How does the court now know that? Yes.
The evidence.
Yeah, where's the evidence
points to that
points to that we are now seeing Mogeni differently? We used to see him this way, and this is how we're seeing him. Are there witnesses coming to court to say that I used to see Mogeni with a lot of reverence and a lot of respect, and after this story, I'm now seeing him differently. So are there witnesses now to bring out the measure of balance of now how do we tell the honorable man has seen him differently? What is the test?
Yeah, ordinarily, in defamation cases, the plaintiffs or the victims have called in witnesses to that effect, so that it is not just a matter of conjecture, but a matter of fact, which is proven by evidence. So, going back to the case that we are looking at, in this case, the plaintiffs here, that is the Lady Justice and the Senator, brought in witnesses who were people who knew them. And those witnesses were able to testify that they knew the senator and they knew the judge, within certain contexts, and that having heard what was published by the newspaper in this case, they viewed them differently. And ordinarily, this test should be a subjective test. Rather, not a subjective test, but an objective test. It should be an objective test. But for matters of defamation, I think out of zeal and out of caution, parties have chosen to bring witnesses in the cases so that witnesses are able to prove that actually I used to view this person differently, and now I'm viewing them in another way. Personally, I would fault that approach because remember, in prosecution of case, most of the times you'll bring in witnesses who are favorable to your case. Remember, here you're not bringing in a witness of an expert witness. You are, in this case, a lot of times they brought in witnesses of fact who say, I viewed them this way, now I view him this way. I think, in my own view, in such cases we need to bring in expert witnesses. I know this would be controversial, but surely for purpose of protecting freedom of expression, we need to bring in witnesses, expert witnesses. In a lot of the times, when a demand letter is written to a media house or a person who has published, that demand letter will always say, for cease and desist publications, retraction, and issuance of apology. And as a lawyer who oftentimes represent media houses and people who are accused of defamation, we like to pull out the line that in the first place you didn't have any reputation worth degrading. So if you don't have a reputation that is worth, there are some people in this society who are rotten to the core. I mean, somebody has already been charged with corruption, found guilty of corruption. In fact, some have been convicted, and you find that those people still, have got the temerity to come out and claim that you have harmed their reputation. So my own thinking is that bringing in witnesses of fact who to testify about them viewing you in a different light really isn't being objective and isn't helping the law, because I mean anybody would bring in a witness who is favorable to their case. So even if it was my nephew, I can bring in my nephew and say, my nephew will say, I used to view my uncle in a different light. Now, because of this publication, I view him as a person who has got no integrity, even if they know that I actually didn't have any integrity. That kind of partisanship. So an ordinary man generally has been regarded to be the man on the streets, and it's a judicial standard. If you read a lot of common law decisions, it is a judicial standard which is applied by judges. My own view is that much as you bring in witnesses who are favorable to your case, what is important is that you prove that there was defamatory publication, and that defamatory publication was actually was false. As to harm to reputation, I think it's a matter of judicial weighing.
Okay.
Yeah, I think it's a matter of judicial weight.
So the question is,
Yes.
in that matter, and in that case then there's an aspect of the judiciary system where I feel like it is the core of any other case, apart from defamatory cases, maybe criminal cases, whereby witnesses are called in to testify. And of course, in these, in such circumstances, there's the aspect of oath taking. So here, the oath taking is where the heaviness really lies, because the judiciary, and that's why the judiciary will always find they're trying to promote truth, and they believe that when you come in and actually take the oath, which is very okay with the reason for the Bible are taking an oath to say, what I'm going to say here is true. The judiciary now really depends on that oath that you've taken, that is the truth that you're going to make before us. So where's the balance of now telling, now that maybe you come and take the oath and it's not true? So we really need another like...
But Floyd, wait. You see, much as somebody takes an oath, if you are going to take an oath to testify only about your feelings, I doubt if the oath really makes any much difference, because I can take an oath and say that, I'm feeling sad. It is me, even when internally I'm smiling, right?
But if you're taking an
It's easy
oath...
to act.
So if... Yeah. No, it's easy to act, that's what I'm saying. If you're taking an oath, and that's what the judiciary, a system of that caliber, relies on. That we come and take this oath and they believe what we're going to say is the truth. And you've seen it before, for vetting of senators, governors, and every area of public office. There's oath taking. And of course, they go in and do differently. So if that is our measure of you going to deliver,
we need to change.
And that's, we really need to change. We need to look for the systems to really prove that you're going to say the truth. Because if we depend on oath taking and you're prepared to lie, you're so prepared to lie and you've come fully aware that you're coming to lie.
There has to be like a
we need to need a new system that can discern and tell us now that it can prove, and we need to substantiate that
like
this is the truth and this is,
like a lie detector.
we cannot, we cannot fully depend on oath taking, because if you are keen following up on the impeachment of the Kericho governor, someone there, I don't know how to mention the name, took an oath and actually sworn an affidavit. And of course, an affidavit is a legal document that carries a lot of weight in the legal space. So it's where you sign an affidavit before commission of oaths, and you promise to do this and this and that, and this is the truth. Sworn in affidavit. You appear before the assignment and you say different things, and even people get shocked. People wonder. Like, now, you see.
Now, Floyd, maybe to just comment on that, in terms of oath taking, my view, and I think that it really is the background of it, is that oath taking was supposed to bind you to questions of fact, and questions of fact are facts that are verifiable, and that's why in the Oaths and Statutory Declarations Act, and as well as in the Penal Code, it's an offense, to lie under oath. So the weight of the oath really a lot of the times rests on facts that are verifiable. And that's why we advocates, when we are doing cross-examination, we try to distinguish between actual facts and opinions. So in the event then that we've asked you questions relating to actual facts, and you lie, and there are out there evidence pointing to a different set of facts, then you are liable then as a witness to be cited, one, for lying under oath, which is perjury, but even more importantly, for acting in contempt of court. If you lie under oath, you'll be found to be culpable for lying for contempt of court. But now I want to bring you back to the question of defamation, which is in this case now applying all that, is that the people who are brought in, one, the act of swearing is to make sure that they are swearing to questions of fact only. And that's why I agree with you in faulting, the question of, putting a witness who is going to testify on subjective matters under oath. And, on defense, in defense of judiciary, a lot of the times, all the witnesses will come in and testify under oath, but the judge will choose which witness to agree with. Yeah, so the judge will make a finding that on the basis of the evidence that have been given, by all these witnesses, this is my finding as to matters of fact, and the judges will always go on and on and delineate why they agree with this line of testimony and reject the other line of testimony. Now, in defamation cases, again, it becomes a question that is controversial, because other than the publication, remember, a publication is a publication. You cannot deny it. What is important, and again, it's important, by the way, what is the threshold for defamation? It's important that this comes out. The threshold for defamation is publication to a third party, any third party, so that if, for example, you wrote a letter about me to, say, Margaret, okay? So Maria writes a letter to Margaret about me, saying something else. And I come to learn that Margaret has known that particular fact. That by itself amounts to defamation, because it's published to a third party.
And by published, I think we should emphasize that means any communication to a third party.
Yes,
I
Maria.
need to interject.
Yeah.
Based on how the argument is going, would it be right for us to assume, or rather to surmise, that the test of a reasonable man is relative, and therefore, based on the facts of the case, it will be the judge's discretion to decide whether these facts would amount to something that has injured one's reputation or not, and this one is worth prosecuting as a defamation or not. Is the test of a reasonable man relative in this case?
Depending on the facts?
Yeah.
Depending on the facts of the case.
The test of a reasonable man cannot be relative. The reasonable man, again, I repeat, is what was stated to be the man in the the man on the street, the man in the Clapham omnibus. Clapham omnibus ni kama nini? Ni kama
Nganya.
Ni kama yeah, the man in the Nganya, ama the man in the city hopper. But in fact, by the way, they were like the city hoppers. It's the name.
Yeah.
It's the medieval. Not really. Is it the medieval Britain? I think. Yeah. So that's the reasonable man. It's the man walking in the streets. With a gunia. Coming from work, and it doesn't have to be a professor. It doesn't have to be an engineer. It doesn't have to be a teacher. It's just a person. If you were to hold a conference, zile kamkunji kama zania. In fact, the place to get the reasonable man ni pale nini Jivanji. pale kwa bunge la mwananchi. That's where the reasonable man is. Yeah, that's yeah, hapo kwa commoners. Yeah, that's where the reasonable. So and you see this, by the way, you know, takes us back to, you know, the whole origin of democracy and law. You know, how
this will also make it easier and make it more accurate and fair to the face of us, the reasonable man, and do not have the perception of this is a one-man decision. And
but now again, then in that regard, you support, because you see the way a jury, the way a jury sits, is that jury is selected from just common people. So this is how it happens, you know, in jurisdictions where juries is deployed. A case is filed, a judge is assigned. So you see in our case, you have got a judge who makes a determination on both questions of fact and questions of law. Now, in jurisdictions where they employ a jury, the judge makes a determination only on the questions of law. On questions of fact, it's left to a jury. Now, a jury is selected from just people randomly. Yeah. So, you know, they walk around, you know, go into any jurisdiction and say, you know, so and so and so and so, you are going to be the jurors of this particular case. Yeah, and you know, if you go to those courts, there is a jury box. Hapo hivyo ni wale tu wamekaa tu pale wanasikiza. Yeah, so wanasikiza and so, you know, advocates and their clients come, they present their case, and then you know, a jury determination is made. So the judge basically presides and directs them and tells them, these are the issues to be determined. These are the issues to be determined. So on this question, then they will vote. So the majority of the vote then, you know, determines a question, you know, a decision on that particular question.
That question, there's no discretion of. Does not the judge does not practice his discretion in that matter.
No, the judge only directs them on matters of law. So if the jury has found, is convinced that this particular set of, you know, issue of fact has been proven, then the judge is now bound by that jury's finding to apply the law to that particular finding. And now, either, you know, if it's passing a sentence, then pass a sentence. If it's not passing a sentence, then and you know, they are given a set of issues of fact on which they are going to make a decision, you know, determination. And what is important is that in the jury, when the jury retreats to make a determination, the judge does not form part of that. They don't go with the judge. They go alone. Like, you know, they're locked in a room. They are given that set of questions that, you know, you guys come back to us with your answers on this, you know, how you're going to vote on it. Yeah. So they'll come back and say that on question A, we have voted, you know, 3-2 in favor of no, or 3-2 in favor of yes. Sometimes, you know, it's unanimous. And my feeling is that matters of defamation, because they touch on a lot of public interest, they touch a lot on, you know, issues that should be determined by what, you know, as Floyd puts it, the ordinary man on the, you know, the ordinary man on the streets. It's for me a proposition that it's worth putting across.
So allow me to. I actually think there's a lot of wisdom in having a jury to help the judge in, you know, coming up with a judgment, especially for a case of defamation. Especially when we look at the defense of fair comment, you need common people to tell you whether or not this is fair comment or there was actual malice in the making of that comment. And also, it brings me to a philosophical question. So, in a court case, is it the defendant on trial, or is it the judge who's actually on trial? And allow me to explain why this question is coming up.
Okay.
Because I do feel that there is a case to be made against the defendant on whether or not he is guilty or liable. But the person making that decision is a judge. So the judge might actually be the person on trial because he's the one to determine the liability or the guilt. Does that make any sense?
Yeah, it's interesting because yeah, I would actually almost agree with you that the judge is also on trial in terms of their integrity. And allow me again to digress on this. In the recent past, not really in the recent past, currently, there are petitions that have been filed before the Judicial Service Commission where petitioners are complaining about how the judges exercised their judicial discretion. Yeah, the cases that have been filed by, I think it's Nelson Harvey and a few others against Justice Nixon Sifuna, and there's also another one against another judge. I'm not so sure.
Another one again against the Supreme Court.
Yes, yes. So, you know, these are questions. Some of them are touching on. They are faulting the judge for making a decision in the manner in which they made, and the argument is that the judge in this case made an incompetent decision. Yeah. So in a way, the judge is logically in trial, but in law, it's the defendant who is on trial.
Yes, yes.
Yeah, yeah. So probably the other thing that it's important to look at when it comes to defamation are you want to look at, in this case, what are the defenses that could have been available to nation group or to the defendants. Okay. Yeah, so it is important because defamation is not carte blanche, it's not a blanket. Really, if you look at the Defamation Act, there are layers to it, so that before you are found to have defamatorily to have defamed a person, then there's certain tests that should be administered. So I would want us to look at those tests. What are the available defenses? Because from where we sit, I think it is important that we are able to educate our audience on what are the defenses that are available. How can you escape a prosecution for defamation, and in the event you find yourself being tried for defamation, what does the law speak about your available defenses for you? Yeah.
Lawmaker pushes wife's hiring as judge. This was held to be a true innuendo. Margaret, kindly define for us what a true innuendo is.
A true innuendo is a statement that appears to be innocent, or rather, it appears to be harmless. However, it becomes defamatory the moment where certain facts, which are known to certain persons, are introduced to the case.
Yeah. So I will start this by quoting the Latin maxim of Faber Volenti, Scripta Manent, where it says,
Student of law, talk to us.
We are continuing.
We are continuing, but
okay. So in this legal magazine of Faber Volenti, Scripta Manent, we say that words may fly, but written words remain. So in the case of Mogeni, in this case of Mogeni, where is Senator Erick Mogeni, Okongo, and Lady Justice Jacqueline Mogeni. In this case, we come to find out that where true innuendo really comes in this case is the Nation Media Group did not mention the names of the Lady Justice and even the Senator. But all derogatives drive back to them, and the public could really tell that these are the people being talked about. For example, if you say that a senior senator in Nyamira County has been found guilty of, or has been found to be violating misusing public funds or things of that sort, even though you have not mentioned the name of the person, once you just mentioned senior senator in Nyamira County, there's no other senator in Nyamira County. People know Erick Mogeni. So once you say senior senator, of course it will derive back to him. So even though the name has not been mentioned, it is clear that you're pointing to him. And in that particular case then, of course, now we need the burden of proof.
Floyd, allow me to throw a question to you on that. Does it undermine freedom of expression by itself, that doctrine? Do you think it undermines freedom of expression?
Yes, I think in one way, it does on freedom of expression, because if you are supposed to, and again, for me, what I feel like, why it undermines the freedom of expression is, especially on investigative journalism, it really brings a chilling effect on it, and now it waters down on something we call aggressive reporting. Yeah, because now there will be a lot of fear for aggressive reporting. You cannot report on some things because of the fear of the damages. Look at this case, 6.5 million. Nobody will go ahead to publish cases or bring out reports about such things. So in a way, it brings a chilling effect on investigative journalism, waters down on aggressive reporting. So that is on the other side. But again, it comes up with the issue of, it brings the aspect of, we need something we call liability and also truth. Whereby, even though these are public figures, and yes, we can say that their life is public and there's no defamation in any way, again, there's liability in whatever you report about.
And now,
this.
on that note, let's also talk about anonymous sources and their place in the media. Because I think freedom of expression is also affected there somehow, because if I cannot rely on my anonymous sources because I'm scared that you're going to bring a claim against me as a media house based on a report that I received from sources I literally cannot name, then there's going to be a lot of apprehension about reporting, just as he said. So
yeah, and that's why now there's that catching of line. We're talking about, for example, in the case of on privilege, for example, you see that now into two, whereby you have the absolute one and the qualified privilege. So in the case of absolute privilege, for example, things like court plenary, judicial proceedings, and parliamentary proceedings, there it's absolute privilege. In that case, anything that is said in the floor, we have seen parliamentarians make statements in the floor. Some may appear defamatory, but in that case, there's no information because that's absolute privilege. And in the case of now qualified privilege, now Nation Media Group, as a defense, maybe they pull the card of saying they had a social, moral, and a legal duty to the society, public interest to the society. But again, they're tied of now substantiating and proving the truth and what is not true. And that's why now we now dwell deeper into the maximum of onus probandi, the burden of proof relies on the who accuses must prove.
Interesting. I think what is important always to note, and is where this discussion must always focus on, what are the available defenses for defamation? One of them, as Floyd has pointed out, is truth. Number two is the question of public interest. Number three is privilege. So those are available defenses. And Maria, you were pointing towards something about the use of anonymous sources. Now, one thing is that the use of anonymous sources is a journalistic privilege. It is one that is recognized internationally, that journalists have got a right to have their cases, rather have their sources remain anonymous. And the downside to that normally is that the journalist then takes responsibility for that particular matter. Now, what is important to point out is that much as you have got journalistic privilege to have your sources remain anonymous, that privilege does not extend to publishing false information. And so it then behooves a journalist or a media house that is going to publish something that is controversial, that is touching, to make sure that they are backed up with the truth. And a lot of the times you'll find that where the truth is so solid and it's not based on speculation or rumors only, then the people who are involved rarely choose to pursue any legal cases against journalists. And at this point also, just for protection of journalists, something that they need to know is that they have got a code under the Media Council Act. That is the journalist, the code on media conduct, the code that binds media houses and journalists on ethical reporting. Some of the things that they need journalists to do is to verify their sources of information, make sure that they give the other side a chance to respond to any information before they publish. They should not be biased, they should be factual, they should be objective. But in the context of public interest, and something that I need to emphasize, I think our jurisdiction has severely overlooked the idea of public interest. In advanced democracies, if you look, for example, in the UK or in the US, and there is a particular holding to that effect, it's consistent if you look at judgments coming from the United Kingdom's Supreme Court and indeed the European Court of Human Rights. One of the things that they emphasize is that for public officials, the threshold for privacy and issues of determination is a bit high, for your matter to be considered. If you're a public official, the doctrine is that if you are occupying a public office, then you should be open for scrutiny. Essentially, you should have what, in loose terms, I could say, a thick skin. As a public official, you should not have a thin skin that any little thing said about you which offends you, you run to court. And I think this is something that needs to be explored in our jurisdiction and needs to be emphasized. I personally feel that the judgment that has been, the award that has been made by, in this case of Mogeni, essentially makes it difficult for media houses to publish about public officials. I mean, look at it this way, and I would dare you, let's just go to the facts of this case as it is, and let's, dig down to what are the, what is the profile of the judge in question here. I think it is something that the public needs to know. What is the profile of the judge, and therefore, in the context then in which it was published, ought the public then to have an opinion, and probably want to bring it out, Maria.
Oh yeah, I'm actually looking at the judiciary website, specifically on Honorable Lady Justice Jacqueline Mogeni.
That is the second plaintiff.
Oh, yes.
On the subject matter of the publication.
Yes.
Yeah,
she holds the following academic and professional qualifications. A Master's in International Studies from the University of Nairobi, Bachelor of Laws from the University of Nairobi, Postgraduate Diploma in Law from Kenya School of Law, and she was admitted to the role of advocate in 1995. She has over 27 years experience in the legal profession. And
just hold it there. She has 27 years in the legal profession. I think for a lot of us who are interested on who is going to be a judge of the High Court, you're looking at, of those 27 years, how many of them have been spent in actual legal practice or in actual office of a judicial officer. Perhaps just want to dig it out. I think it's also there in the profile. What is her resume in terms of job experience, the positions she held?
Well, according to what's displayed here, we have previous experience as CEO, Council of Governors.
Is it a legal position?
I doubt.
The other experiences?
Chair, Legal and Intergovernmental Relations Transition Authority.
Chair, Legal and?
Intergovernmental Relations.
authority. Is it a legal position in active practice? Maybe, maybe not. Depend.
Human Rights Officer and Gender Focal Point, UNDP Kenya Country Office. National Coordinator, CBSI. Gender and Advocacy Development Advisor. Children Rights Development Advisor. Program Officer, Gender Violence and Legal Awareness Advisor. Program Officer, Legal Resources Foundation. Shall I also read her other responsibilities?
Yeah, you may. But for me, on the basis of those alone, surely she appears to have experience in the legal profession. And again, this is subjective. Yeah, I think for a lot of people, the question is going to be, she's going to occupy a judicial position, and if she's going to occupy a judicial position, then what is the philosophy that she's bringing to the bench? What is the experience in terms of decision making and judicial administration that she's bringing to the bench? I in no way making a suggestion that she's unqualified to hold that position. In fact, the honorable judge is highly qualified to hold that position.
She has 27 years of experience.
I mean 27 years of experience. But and you see, it is these buts that are of interest to that are of interest to the public. And if these buts are being raised, then it behooves the judiciary and indeed the courts to allow such kind of discussion to thrive. Because what happens is that if you lock such kind of discussions, by making the kind of awards that are being made, the implication of it, the impact of it certainly becomes that people become even more more doubtful. You see, the principle of freedom of expression that wins normally is that freedom of expression should be left to thrive. People should be allowed space to debate. In fact, even that suggestion that she might, her appointment might have been influenced by her husband should be something that should be open for debate and let people speak freely. I mean, the school of thought which I subscribe is that the best response to a lie is to give an accurate fact. Because in this case, what we would have needed was, if the nation has published that and has alleged that her husband, might have influence. I mean, there is something that is said that if it walks like a dog, if it quacks like a dog, it is not a camel. That's what they say. Yeah, it, might as well be a dog. So it's then in the discussion space, in the expressive space, it requires that you, who is the holder of the truth, just bring that truth outside, and you will settle the debate. Never mind the fact that a lie shall have gone around the world 7 times before the truth goes once. But
Floyd, before you speak, I would like to ask you a question.
Yeah, sure.
So, would you say that headline, Lawmaker pushes wives hiring as judge, should have been considered fair comment? And also, would it have been better off if these people just named them outright? Because I feel like that was the whole premise of the case.
I feel like what you're saying,
alluding.
Yeah, because what happened is this. Lawmaker pushes for wives hiring as a judge. And you've asked that if the...
I'm asking
when it should have been held to be a fair comment.
Yes, and also if there would have been a different outcome if they actually named the names.
Because the court has said, this is what the court was arguing, and it was, the thing was, if you are, for example, okay, so you have said that if the court will have named, and that's the thing, I wanted to comment something on what you've just said. If the court, if they had mentioned the names, or, so what happens is this, what the court expected, and that's why we want to clear, and that's what they wanted is, for you to make such a claim, we want justification of what you have said. So in that case, for us to rule out malice, Nation Media Group was supposed to do its due diligence and call the parties, the plaintiffs, who is that is the claimants, who is Lady Justice Jacqueline Mogeni. So what happened is, Nation Media Group was supposed to call them and to verify that is it true what we are hearing from her end that you have pushed. And there was the issue of saying that she was coached for the questions and she got information about the questions she was supposed to be asked. So Nation Media Group was supposed to call and verify from them that is this information true. So once that part is skipped, for you to justify from them and them to tell you their side of the story and to just go ahead, you become now partisan and you decide now you're going to do things your own way. And you say, as you have heard the story and this is what we have with us, we're going ahead to publish. Without the other party also hearing out the other party. And it's part of what carried water in this case. The other party has not been contacted to give us, to tell us, is it true what we are hearing here, and give us your side of the story. So once you do things from your own end, yet on their own end they're not being consulted or they're told to give facts about the case, then in that manner then there's malice. It's clearly malice.
But Floyd, it might not be fair comment, Maria. It might not be fair comment because this is a reporting of, it's a factual reporting in the way it is coming out. But let's look at the context in which it is being written. You are looking at a situation where somebody is going to hold a public office. The person who is concerned, to whom they are related, is a holder of a public office. You see, essentially, these are people who are in the public space. And the doctrine of public interest requires that public officers are open to discussion and scrutiny. And the best way to assuage the public court is to come out with the truth on your side and settle it at that other point. So that for me, much as the defense of fair comment might not suffice in this particular case, the defense of public interest remains alive, well, and available in the particular case because this is a holder of public office. If you are afraid of being scrutinized publicly, if you are afraid of speculation about your qualifications, about the propriety of how you access offices being discussed, then for me, you do not have, you have no reason holding a public office because public office, and remember, oftentimes, people who are holding public offices have got the unique privilege of exclusive access to information. And in this case, if you are looking, for example, at the question of influence, there is a possibility. I mean, what does it cost for a public officer to come and say this, space is not true, rather than pursuing a case against a media house? For me, I want us to look at it in terms of the impact of it on the media space. One, the subject of the award is a judge of the High Court, all right? Number two, this judge is a person who will be sitting in cases that come before the judiciary. And so what then does it imply if a judge becomes the beneficiary of a defamation case against a media house? What will follow is that that media house will have been intimidated from ever reporting anything against judges. And I think that judges especially should be able to allow themselves open space for scrutiny. And that is why the judiciary has got a judiciary spokesperson and a fully fledged communication department to deal with such kind of controversies. Because when people are publishing such kind of information, what they are doing is to open space for a debate, whether there is a full play that could have gone on. And then it then behooves the people who are occupying those spaces to provide answers that are being raised in those discussions so as to settle the debate, because otherwise what happens is that, the downside of stifling debate on anything that is speculative is that it actually entrenches it.
Yeah,
Because,
fear.
yeah, because what happens is that now the debate happens now in the underground and in silent, unguarded spaces. So people don't publish it anymore. But you just say it is flying. It's being rumored. It is being speculated. It's being whispered here and there. And I mean, for me, and definitely, at one point or the other, being in this profession, I surely will might appear before the honorable judge. Yeah. I don't know, how I would feel appearing before the judge, knowing very well at the back of my mind that this is the judge whose process of ascending to office was questioned, and she responded by getting a court order to stifle that debate. So essentially, for holders of public office, it sends one, a chilling effect. Number two, it creates doubt as to the propriety through which they access the office. So even practically, away from the legal question, the practical effect of it is to make people view the judiciary and public institutions with a lot of doubt, a lot of suspicion that these are people who are very very self-protective and not open for inquiry, discussion.
But on what you have said, yes, you have expressed what you feel. Again, I also have some thoughts on the same, because I feel like if the Lady Justice, let's say for example, Nation Media Group, so the way they made the defamatory statement on about her rise to office to as a judge, and if, let's say for example in the case, the Lady Justice did not respond completely to the allegations, yeah, because we are looking at one side.
And in fact, Floyd, the fact here is that she didn't respond. She rushed to court.
Yeah, okay, she rushed to court.
Yes.
So let us put it, because remember that the judiciary is one of the arms of government, the third arm of government, yeah, and a lot of people is a place where those people who feel that their rights have been infringed on, run there expecting to get justice.
Yes.
Okay. So once our work as a public or even media stations will be, media houses will be to throw stones at the judiciary, which is not wrong in a way of risking accountability. But at the same time, what do you think now happens to us in the public who know very well that, for example, she can't respond. She decides to go quiet on the whole topic. Then it leaves the perception that this story is indeed true, because that silence means something. Or even she communicates something and that's like she's covering up. And people believe it is true, she rose through those methods. So when an advocate like you now appears before her, and you already now believe that, because it's relative, maybe you will believe that it is true, that's the method she used to rise, to become a judge. So how do you view her when you go there? And now you believe that that's how she rose. You feel like she's incompetent. So where does it put her as a person? That now you believe that she's incompetent. And again, this is a third arm of government. So once you taint it and soil that arm, then you even kill public trust on the judiciary. So they won't trust the like, why should I go to court when even the Lady Justice herself, who is the judge of the employment and the labor relations court, rose through corruption?
Let me respond to you, Floyd, about that. Kenya is one of the countries that subscribe to the principle of open governance. Now, the principle of open governance entails a number of things. It entails disclosure. It entails free communication. It entails, in the context in which we are discussing, responding when questions are raised. Now, a duty of anybody who occupies a public office is to give answers to people who question anything about that public office. That is the essence of Article 35 of the Constitution, access to information, all right? And so the essence of having a public debate about how somebody has ascended into office, even if it is speculative, basically, you know, being speculative is not to throw stones. Being speculative is to raise questions and to put it in the public. It was the most perfect opportunity for me, if you would, for the judiciary to lay bare that their processes are indeed transparent and the people that they are bringing onto the bench are indeed qualified. It would have helped the judiciary more, in my view, and I think in principle, to respond to the whole question of what was raised by the nation, to provide a response, one, as the judiciary, that the judge whom we hired, this is the process through which we took her, all right? To respond that we did not give any preferential treatment to any journalist, rather not to any journalist, but we did not give any preferential treatment to any candidate by virtue of their position in the society, by virtue of the position of the people they are related to in the society. They did not give any preferential treatment to anybody in any manner whatsoever. And also for the judge, it was a perfect opportunity for her to come out and say that I did apply for this position. I mean, we have seen in cases where curriculum vitae of judges and public officials have been published outside there. I mean, what stops you from publishing your CV and demonstrating to the public that I am indeed qualified for this position and I did not get any favors? Because let me just finish. Because in this context, what has happened is that the judiciary, not really the judiciary, the court, has stifled a debate, a discussion, all right? So the questions that were raised by the nation have neither been answered by the judiciary nor the candidate herself. The public views that, you know, this is something that, again, back to the question of the ordinary man in the street. The ordinary man in the street will be like, a question was raised, instead of responding, they responded with a hammer, 6.5 million. So if this can be thrown at nation, I want you to look at it this way. From the point of view of smaller media houses that are just rising, yeah, say, you know, the podcasts of this world, say the smaller publications, the blogs of this world that, you know, seek to stimulate debate. What should be available for them is that such kind of discussions should be left to be open, even if it means that it's being open through speculation. That is the essence of public interest, and a public officer occupying a public office must allow themselves to be scrutinized. And when you are scrutinized, you don't respond with hammers and stones and, you know, bullets.
Yes.
You respond by publishing that this is the truth.
But from, okay, it's okay. But from what you have seen, yeah, what is the point of, because it is very clear through the judicial website, it is very clear that she's qualified. And they say, for you to become a judge of the High Court, you must have 10 years experience. Or in judicial practice or anything of that sort. Or as a judge or a judicial officer. You must have competence in that area of law. Of course, she's competent in that area of law. You know, matters of environment and stuff.
Are you sure?
Have you read? Yes. From the qualifications.
Let's go back to this.
Yes.
My experience.
Okay.
She has over 27 years of experience in the legal profession.
No, the other part of environment and truth.
Yeah.
Read that.
She was appointed as an environment and land court judge in 2021 and has served in Nairobi.
That's the not really. That's what was in contention in the publication.
Yes.
So for her to be qualified for that position, her previous experience.
Right. She was CEO of the Council of Governors.
Yeah.
Is it a question? Is it a position in land justice?
No.
Chair, Legal and Intergovernmental Relations, Transition Authority.
Is it a position in land law?
No.
Human Rights Officer and Gender Focal Point.
Is it a question of land?
No. What is the
No.
full name of that court?
Environmental and Land Court.
Okay.
Yes.
So she was
National Coordinator, CBSI.
What is CBSI?
I have no idea.
We need to know. But I doubt it has got, if it's got anything to do with land.
Just advocating for climate. Have on credit.
Yes, it can be anything. Because the same.
There
it can
is
be
something
judicial.
about the Nile Basin.
Yeah,
Initiative.
it can be the judiciary overlooked the competence in that area of law. It can be the Judicial Service Commission overlooked that. It can't.
Okay, gender and advocacy development.
The judiciary overlooked that.
Children's rights.
Yeah, children.
Program officer gender violence.
So it can't be the judiciary overlooked that.
Okay, Floyd.
Yes. And
Okay.
look at it.
I kind of understand where you're coming
And
from.
look at it.
Because I also have a question. So
Yes.
are you saying you must have gone to court and
No,
seriously
they're
tried
saying
to
you just
know
must
in
have
court?
competence in that area of law. And despite that, there's another question I wanted to raise to Akil. Yeah? There's something, you know, in every media house, there are laws governing. Rules are rules. You
Yeah.
can't, rules are rules. There is the fact of you must substantiate what you're saying and you must verify. The part where the media station bit is, you know, I can't wake up one morning and I wake up and they say that Floyd, a student in law in Kenyatta University, was caught in Ngara yesterday, maybe smuggling goods or drugs, using drugs.
Anonymous sources.
Yeah, so that's the point. And that's what they say. For you to publish that, I can't wake up and find something that I am not informed or well informed about. I should, when you begin, have told me, by the way, tumesikia hivi na hivi. Tell us your view or your truth about this story. So that when I go to court, I say, by the way, to contact Floyd, and this is what he told us that pushed us now to publish this. So once you don't reach out to me, and you go ahead to publish, because even though we are crying and saying that the media houses are being, the freedom of expression and of course the freedom of the media, Article 34 is being compromised and things of the sort, we're trying to say, again, media houses have a responsibility. They have a responsibility. You can't just publish stories, not even confirm them from the end of the story. You have to reach out to me and tell me, what is your truth about this? I can't wake up in the morning and find myself there, my picture there eating this. You're saying
So, in this situation, it was not a random situation. No, you just woke up in the morning and
no, she found the information in the media.
In this situation, vetting was going on, and this is vetting for a person to occupy a public office. And the facts were, they said there is a talk, so it's more of like an invitation to the public attention. In as far as like how far the city is concerned.
What the media house
the best
did,
thing to do was to justify.
They skipped an important phase, which was the other party to be heard. We're talking about fairness here, equality and fairness. There's unfairness there.
Now, Floyd.
They're supposed to be contacted and be told. And it's a fact in the case.
Now, Floyd, I get you, and I agree with you, all right?
Yes.
That in so far as publications are concerned, one of the principles that is required of media houses is to do a verification and to be balanced. It is a principle. We have got no qualms with that. We have got no quarrel with that. But what we have got a quarrel with in the context of this particular judgment is the circumstances under which it is issued. All right? So what are the circumstances? It is a judge of the environmental and land court, right? Remember, one of the principles of public service in the Republic of Kenya is the principle of meritocracy, right? Meritocracy means that of all the candidates who have presented themselves in terms of qualification, in terms of subject matter knowledge, yeah, you surely are amongst the best in that subject area, knowledge, okay? And you are not just the best in terms of subject area knowledge, but also other factors considered, like regional balance, other factors considered like gender balance, other factors considered like, spread of opportunities, in the terms of equity, essentially, okay? All those facts have been considered, right? And so it is it is a principle of freedom of expression. And I want to invite you, okay, and anybody else, to go and read the general comment number 34 of the UN Human Rights Committee, right? General comment number 34 on factors that should be considered in protecting freedom of expression. Remember, freedom of expression is at the backbone of democracy. Always, at any given time, remember, there is no democracy without freedom of expression. And if you go and check the Constitution at Article 22, 21, 22 on, interpretation, check 21, 22, but also go and check, I think it's somewhere between 55 and 57, on how the Constitution should be interpreted insofar as human rights are concerned, okay? And it says that in interpreting the Constitution or in applying these rights, an interpretation should be adopted that expands rather than limits, okay? So that if you have got an interpretation whose effect is to hit at the core of freedom of the media. In fact, now let's bring it, straight to freedom of the media. This is Article 34 of the Constitution. So for Article 34 of the Constitution says that media houses and broadcasters and publishers shall publish without any interference. Number two, one of the other principles is in terms of penal consequences, and I by no way am suggesting that this is a penal consequence, because this is purely a civil, consequence, which is, by the way, within the acceptable, practices when you're dealing with the issues of freedom of expression. What we are saying is that such kind of hefty awards, and in the context in which it is being issued, threatens freedom of expression itself. The aspect of freedom of expression that it is threatening is the public interest aspect of freedom of expression, which by and of itself is a defense to defamation, okay? So that if somebody is publishing in public interest, all right, whereas the court, and you see the courts have got the space and the discretion to consider and even find as matters of, make a finding that in fact defamation has occurred here. But the courts have got that, the other sense of justice to say that, whereas I do find that these publications were offensive and, certain journalistic principles were not adhered to, I, however, in public interest, do, order as follows. I mean, for me, this is a case where a public apology and, an order for retraction would have been sufficient, rather than issuing an award of that.
Okay,
an
this
award of
is the
damages.
point. That's what I'm saying. It's an issue. Let me just make my point also. I think the law is a double-edged sword in this case. And if you look at the history of how defamation cases have been handled previously,
Yes.
and even of date, look at the case of Musukari Kombo versus Royal Media Services,
Yes.
and you look at how they're doing it.
Yes.
Is an issue of we are debating about principles of law. For example, if you look at the precedent being set of these cases, Musukari Kombo, the one we're having here of Mogeni case, is an issue of the court system following the principle of stare decisis in handling their cases.
Now, let me cut you on that a bit here. Now, we are the essence of the 2010 Constitution, right? Was to, in spite of those developments. Remember, the era of hefty awards in damages actually began with a consent. It begins with a consent between Honorable Biwott and the late Honorable Biwott, and I can't remember the exact media house. I'm not sure if it was the Standard or it was a settlement, okay? And in that settlement, I think it must have been about 16 million Kenya shillings. Now, unfortunately, courts started following that particular settlement as the precedent, okay? So much as the doctrine of stare decisis, is applicable and it's plausible, in the context in which we are looking at, what is happening, and it's a trend that I think needs to be questioned, yeah? And, for me, I want to take opportunity in this podcast to start questioning it. I mean, how come the biggest beneficiaries of hefty awards are public officials? all right? Look at the trail of all the presidents we are talking about. Musikari Kombo, Biwot, now Senator Mogeni and Honorable Jacqueline Mogeni. Look at the case of the former Minister Murungaru, against John Gidongo. I can tell you, without any doubt, that over 80% of them often touch on public officials. So that the trend that we are having, which is an unfortunate trend, and which is unfortunately being aided by our own court system, is to help public officials to run away from accountability using lawsuits, and more specifically, the tort of defamation. Okay, so my proposition is this, is this, that where it touches on public officials, because otherwise we will not have people commenting on matters that are touching on public officials. So kila mtu atakuwa hii ni huyu ni cabinet secretary for whatever hii eka kando kwanza, and that is how democracy starts to erode, because people are
scared.
So in your context then, it means you are raising doubts on the competence of the Judicial Service Commission and even the current justice who rule on that matter. Because
no, not at all.
Because now let me now dissect of that. Because let's look at it. Which body is in charge of the appointment and vetting of judges?
Floyd, for the record, we are not raising doubts as to the competence of JSC. We are not raising doubts as to the competence of the Honorable Judge. We are not raising any doubt as to the integrity of the Honorable Senator, who is a senior counsel. What we are saying is that if we allow such kind of decisions to hold, to take hold, it will create a situation where people do not question these institutions. All right. Remember, people have got a right to question. Okay, that is the essence of. The people we place in these spaces are human beings, and is it not a truth that a lot of the times improprieties and malpractices have been unearthed in these spaces? Okay. And it takes whistleblowers, and it takes serious discussions for these things to come through. What we are saying is that these institutions must be accountable. Yeah, we are not doubting their competence. Yeah, what we are calling upon is their accountability, and that is the space of freedom of expression, accountability. Okay, so that once these matters are raised, the essence of it is to provide a space for people to discuss that. Are these people exercising their office accountably? All right? Are they issuing decisions in a manner that reflects the principle of meritocracy? And how best to do it other than to provide proof?
And also, we have decentered this conversation from what it originally started as. Because the entire conversation was about the implication of this judgment on freedom of the media and freedom of expression, not whether or not this judge was actually qualified. Although I do believe that for public officials or anyone holding a public office, the citizenry should not be scared of questioning the competency of these officials, because at the end of the day we rely on them. We are going to go to court, and they're the ones who are going to be judging our cases. So we need to be sure that whoever is judging my case is actually qualified to judge the actual case. But then again, this particular discussion is still about the implication on freedom of media.
Remember, this is an issue between the Nation Media Group and the judiciary. There's no citizen who has raised.
But the media is responsible for reporting to the citizen.
Floyd, look, the principle, the place of the media is the voice of the people.
Exactly.
All right? The media is the eyes of the people. We cannot all go and stand at the gate of Supreme Court and start, asking the Judicial Service Commission that, hey, how did you hold this? We rely on the media.
You rely on the media to express the opinions of the public.
No.
Absolutely.
What do you mean?
You rely on the media. That's why they publish.
So
Floyd.
if the statement is defamatory, so what do you mean
Floyd.
that the public is the voice of the public
Floyd.
if it's not expressing my voice?
Let me explain something, okay? How do you know that you are experiencing pain? When something comes into contact with your skin and the neural nerves, the nerves in your body relate to your brain that something is coming into contact with your skin and it's causing discomfort. The media is those nerves in this case. They are the eyes and ears, okay, and senses of the people. They are meant to report to you what is happening so that you can act accordingly. Because also,
if the media
And
reports,
also to
sovereign
add
power,
that,
sovereign
and also
power.
to add that, Floyd, yeah. Remember the unique, positions that the media, occupies. One, they are having trained journalists, okay?
Mhm.
Number two, they take their time. They invest their time, okay, to go and dig out information. That is the space of investigative journalism, okay? You see, you as and you see the reason why you need the media to do this, yeah, is because you and I, while we are busy practicing the legal profession, okay, we do not have the time to go and raise these questions, okay? We rely on the media, and probably, we are one day gonna hold a discussion on, the role and place of the media in democracy, okay? Yeah, we're gonna have that discussion. But in a nutshell, the role of the media in a democracy is so vast. And one of them is to question on behalf of the people, all right? Two is to raise discussions and generate those debates on behalf of the people. I mean, take for example, right now, the podcast we are doing here is going to be published, all right? It then assumes the place of the media. Not all Kenyans can take their time and come and sit on this. You would never have enough bandwidth, okay, to accommodate all Kenyans, debating on a particular issue. And so it behooves those who have got the resources, who have got the space, and who have taken their time to make that investment to raise this issue. Remember another thing, the media is essentially the public square, all right? So that, in the past, in the ancient civilization, people would walk from their houses and go into a public square and hold debates there the whole day. Something like what happens at the Jivanji, right? So the Jivanjis of those, ancient times, were of the ancient civilizations were the media. Then, with time, people realize that, we can publish. So, I mean, why would we have to walk every day to the public square to have these discussions when it can be published? And again, now with technology, these people are able to, interrogate, they are able to investigate, and are able to then stimulate that the discussion. All right? So you cannot say that the media, so if the media do not speak on your behalf, yeah, again, if that particular piece do not speak on your behalf, the reason why you need that media not to be censored is because it then gives you the opportunity. You as Floyd, you have got an opportunity, yeah, and a right to write to the editor of that particular publication and say that, hey, I disagree with what was published, yeah, and I disagree with it for the following reasons.
let me tell you something.
Yes.
I realized to this whole discussion. This discussion is and that's why it's the law.
Yes.
That's why you call it the law.
Yes.
And I repeat,
Yes.
the law is a double-edged sword.
Uh-huh.
You cannot behave as if one aspect of law is really greater than the other. In this sense, even though we advocate for the freedom of expression and freedom of the media, through Article 33 and Article 34 respectively, we also know that this constitution is there to give guidelines. There's this article, there's the name, every right comes with a limitation. And we cannot behave as if all these freedoms don't have limitation. If you overlook the limitations of these freedoms, then we are losing it. Because we will focus on, I have a right to life, I have a right to this. Of course, the right to life is of course, it's only for everybody.
It doesn't have a
limitation. But once we start limiting, in the field, we start limiting.
Actually, the right to life has a limitation.
Yeah. So it is an issue of, let us not behave as if there are no limitations to these rights. Because if we now make these things to be now like they are absolute and they do not have limitations, then we will encourage impunity in one way or another. Because now we'll be overlooking the limitations and praising now. Yes, it's a right, but it comes with the limitations. You can't do this on a banana republic where you do things the way you want to do them.
Now, Floyd, let me guide you on this. Yeah, I want to direct you to go and read Article 24 and 25 of the Constitution. Now, these talk about how rights can be limited. What is the criteria for limiting fundamental rights? Okay. I also want you to go and look at Article 33, Article 33(2). Okay, on what are the acceptable limitations. I also would want you to look, and this is now we are getting a bit scholarly. I said general comment number 34 of the UN Human Rights Committee. I also want you to look at the International Convention on Civil and Political Rights. Okay. Now, as you say, the law is a double-edged sword, and there are limitations. Okay, that is accepted. There is no doubt about that. Yeah. The good thing about our Constitution is that it goes further to prescribe how those limitations should be prescribed. Okay, and one of the common denominators in limitation of fundamental freedoms and rights is that those limitations should be by one, law. All right. Number two, they should be proportionate. Okay. Number three, they should be reasonable and acceptable in a free and democratic society. Okay. That is the baseline of it.
Okay.
That whereas these limitations are there, they should be limitations that are acceptable in a free and democratic society. And so what is then a democratic society? Yeah. A democratic society is a society that is governed by rule of law, separation of powers, and public participation, access to justice, and all those definitions that apply to a democracy. So we are in no way disagreeing with you about the limitations. What we are saying is that whereas these limitations are being applied, and that is at the crux of freedom of expression, those limitations must be done by law. Number two, they must be necessary. Number three, they must be proportionate. Okay? Yes.
So, from what she has said, you have just gone to the issue of a democracy, which I'll just touch on it lightly.
Yes.
I won't discuss it.
Yes.
In this same separation of law,
Yes.
there's a guy called a scholar. He's called, that is, I think it's in, is it constitutional law?
Mm-hmm.
Yeah, it's called Charles Montesquieu.
Yes.
The principle is the tripartite system, the separation of powers.
Yes. Yes.
There's the aspect of the independence of the judiciary.
Yes. Yes.
And that is an aspect of the tripartite system of Charles Montesquieu. He says the independence of judiciary is paramount in any system, in any democracy. The independence of judiciary is very paramount. Another question that I've heard Maria raise was the issue of the damages that Lady Justice was awarded, and of course the plaintiffs were awarded.
Yes. Yes.
Of amounting to almost 6.5 million Kenya shillings.
Yes. Yes.
But again, the question is, there are mitigating factors in this whole scenario. In the case of, in this case, for example, there is the issue of unqualified apology that is made by the media house, which is a mitigating factor of reducing the charges, whereby of reducing the damages. Once you make an apology, a public apology, and a qualified apology, of course, it's a mitigating factor, and of course, there will be a huge reduction on the damages that, of course, the court has rewarded the plaintiffs. So in this case, the Nation Media Group give or offer unqualified apology to the parties in this case.
No, they didn't. No,
So
they didn't.
why is the
Now, the
complaint
question is
of the high
now
damages?
let me take you back. No, they didn't. Okay. Remember, it was one of the prayers in the suit. Okay, that they retract and that they issue an apology, and also there was the prayer that the damages be awarded. All right. Of all those, the presiding judge chose to go with only the last prayer of damages. Okay. Didn't go with retraction. Didn't go with the question of issuance of apology. Okay. So it takes us back to the question that we were discussing. You know, the crux of the discussion. What is the implication then of issuing such kind of an award in a defamation suit? Now, this is a question that must be considered in the entirety of the context. The context here is that we are one, a democracy. All right. Number two, the context is it is an award against a media house which is at the core, which is at the backbone of a democracy. Number three, it is an award in the context of an publication that is scrutinizing a public process, a process that behooves everybody that is participating in it to be transparent, to be open, and to be forthcoming with every bit of information that is sought. So that what happens here is that with such kind of awards, then you have a situation where smaller media houses, remember, Nation Media House, you know, Nation Media Group and big media houses, they can pay off these damages as are awarded and continue with business because they have been established for long. But think about it, about a media house or a publication that is just taking off. If they see that such are the kind of awards that are being made against media houses, I know there is the value proposition that will be made that such kind of awards, they send a signal to the media industry that you must do your work, you must verify your sources, you must be balanced, you must be unbiased. But where then is the place of whistleblowers? Yeah. Remember, such kind of information, a lot of the times they come from whistleblowers, which then takes you back to the question that Maria was raising about anonymous sources, which is again a source of journalistic information that needs to be protected, and for us to be able to advance a democracy.
So in short, the freedom of free press is being suppressed in Kenya.
What do you think?
Okay, so basing on, so I will nini kidogo.
Yeah, what do you
Not on
think?
defamation, but
Yeah.
I will be around there on the issue of free press. I think, yes, for me, I would say then if that is the precedent that we have been having, remember on the advantage is we have been on different occasions, going to different conferences and different discussions on the same. And of course, we have been seeing of late, we have been having discussions, and we have been saying, last time the discussion we were having was about the CAA on shutdown of media stations.
Yes.
The other one was the one in 2018, the swearing in of Raila against the shutdown of media stations. So maybe it's let's say maybe free press is being maybe suppressed in the country.
No, we are Floyd. We are by no means trying to force you to hold our view. Yeah. Yeah. But what we are trying to say is that we, as especially let me speak for me. Yeah. And I think for many who hold that view, ama magio na nasema wewe na hizi damages unasemaje jamani? Yeah. So what we are saying is that in terms of the awards, and essentially with this, then we are questioning what we are discussing is judicial determination and administration of defamation cases. The debate that we are trying to advance here is that is the judiciary, through the way they are adjudicating cases, participating in infringing on freedom of expression. I personally, I don't know, Maggie, what do you think? If you look at the trail of cases, you have this one, it was 6.5 million. The Musikari Combo one, I think it was an even higher amount. The Gidongo case was about 18 or 20 million. They've always been hefty awards against media houses. They are the kinds of awards which have the capability to literally cripple a media house. And so what we are trying to say is that the courts handling cases in a manner that is chilling to freedom of expression. I think so.
I also think so, because I feel like those hefty fees are where my problem lies. Because you can give the apology, take back the statement, and maybe award maybe a much less hefty fee, which would reach the same objectives. But then to cripple or to attempt or nearly cripple a media house over claims from anonymous sources,
I think
when you had the option of proving your qualifications, provide information to show that I earned this office. I earned this office.
Did the Nation Media Group put him as a defense of an unqualified apology to reduce the damages?
Pardon?
Did Nation Media Group actually consider it as a defense of actually offering an unqualified apology as a mitigating factor in that case?
But by the way, as part of the facts, it was actually a factual contestation as to whether that unqualified apology was sought. In the pleadings, it was pleaded that the plaintiffs had wrote to the media house to demand a retraction and an apology. But that evidence was not produced in court. So if you cannot prove in evidence that you sought that unqualified apology and retraction, then probably you didn't exercise your right, because one of the grounds for qualified privilege is that once that is sought, then it acts. But by the way, for purposes of the Defamation Act, it doesn't by and of itself eliminate your liability. Yeah, it doesn't eliminate your liability. What it does is that it reduces the quantum. You know, it's to be considered by the court in reducing the quantum that can be awarded against you. And so the court can, you know, probably just award a minimum quantum in terms of what it considers would be appropriate compensation. So what I'm still holding again is that in terms of what the court awarded in this case and what courts have been awarding consistently against media houses basically are contributing to erosion of the civil space. They are threatening and intimidating the media. And for me, by the way, I interact with this almost quite frequently in spaces where you find journalists, especially those ones who are coming up. They say, you know, that, hey, on this one, hapa lazima tukue keen kidogo. So it's promoting what is called self-censorship. So it's something that, because of this kind of awards, journalists are tending to veer towards that side a lot of the times.
So, what if you reason and say, if the court says in its defense that that's why we are giving these high penalties on defamatory cases, is because we feel like if an unqualified apology is offered, of course it reduces the costs. Yes, you say the liability still remains, but at least the cost will go down. So once you fail to do it, and you are not, it's not in your mind to offer an apology, unqualified apology, to give a public unqualified apology, then it feels like the defense will be like, it's as if you acted out of malice, and you're not really willing to take liability for your mistakes. And for that reason, I'm going to give you a huge penalty. I'm going to charge you big, because you have not shown. It's an issue of showing. It's like showing remorse. Like, yes, I've accepted that there's a mistake here, and on my own end, in my end, I decided to reach out and actually offer an apology. So once nimekukanyaga, yeah, and it's clearly nimekukanyaga, you see, then I have to wait for you to take me to court to wait for the outcome. I can't even come to you and tell you at a personal level that, by the way, I'm sorry, this is what happened, and I'm very sorry. So once that's impunity, that I wait for you to go to court, it's not start crying, but that nini is very huge. That's about 6.5. And you've not even, it's a mitigating factor. So if you know you can offer an apology and the cost goes down, why not offer the apology?
But look at
it. Shows impunity. Wait until you are hit with 6.5 million. Then is when you start complaining.
Was it proven? I'm sorry. Was it proven that they lied?
Yeah.
Was it proven that they lied?
The court proved. Of course, if it's defamatory, then the court proved that on their end that it was defamatory. Remember, this is a court. Let's not go there, because this is a court.
Yeah, you know what we are trying
and the high court in that manner.
What we are trying to bring is the defense, which is you know truth is an absolute defense. But the truth is an absolute defense. Yeah, so that if you have it and you can prove that this one is particularly true, your case imeishia hapo. Yeah, and a lot of the times, if I have a client who tells me, we are not demand sijui ati to retract your kitu, niko na nini, niko na evidence kwa karatasi. Niko na evidence kwa karatasi hapo unajua that's the situation where unawambiaga, we have noted the contents of your demand letter. Please go ahead and sue. Please go ahead and sue. They're never suing for a fact. They're never suing for a fact. That is, if at all you have got solid evidence, even if it is from anonymous, even if it is from anonymous.
So the fall on national media groups end was to fail to substantiate the truth on that matter. That is something we are agreeing. That they failed.
They couldn't disclose their sources, so they shot themselves in the foot.
Yeah.
Yeah, but
self-inflicted wound.
Well,
failed to offer an apology. Failed to substantiate. Look at it.
Floyd, it sounds vindictive to say that. It sounds vindictive to say that, because you can't say it as self-inflicted. Because remember, journalists have got a duty to protect their sources, yeah? And it is something that the judiciary knows. It is something that judges know, that journalists have got a duty to protect their sources, and that is where whistleblowers, are protected. Because if everybody was going to disclose that, unajua, niko na truth na hiyo truth niliambiwa na so and so, my friend, you will not have whistleblowers.
Then why is it not a defense?
Sorry?
Why is it not a defense then? It's not part of the defense then. Then the aspect of the court knows and understands that the law, the media houses, as a law governing them, they have those anonymous sources which should not be disclosed. So if that is a rule and it is there, it is legally recognized, then why can't it be a defense in this case then?
Now, let me tell you where that defense comes in. Public interest. That is where that defense lies. Yeah. It is where that defense lies, that where an information is published in public interest, then it is a factor that the adjudicator should take into account, that there is an information that has been published in public interest, and is published in public interest because it is touching on a public office and a public officer, and these are people who have got nothing to hide, yeah. And you see, reacting to the sentiment that you said earlier, unajua mtu kama amekukanyaga kwa mguu, yeah, anaweza kuwa amekukanyaga kwa mguu kwa sababu you are walking slowly on a public path, yeah, ndio amekukanyaga kwa mguu, amekubali amekukanyaga kwa mguu, lakini unatembea pole pole,
hajakubali. Where's the apology? Where's the
wewe unatembea
apology? Also say, so we just president create.
Yeah, but
don't walk slowly.
But why can't you have an apology once you realize I'm walking slowly and you stand on me? And do you know I'm walking slowly? Yeah, do you know I'm walking slowly? Do you have reasons as well? Maybe I'm sick.
yeah, so if you're sick, ambia niko mgonjwa.
Yeah,
I should walk with a tag on my back.
Yeah, primary school, I cannot speak English in the Bible. I cannot walk fast. That we know we are to Msumbu.
It's not easy. Winning is winning in this city.
Well, these are very contentious discussions, and I think it's important for us to define for our audience terms like hate speech, innuendo, insult, defamation, satire, sarcasm, friendly ridicule, so that they can know what's defamation. Like, naweza kwambia nini?
Na useme hapa.
Unipeleke kwa court and then I'll be surprised by wow.
Even I've had cases and even the defense, especially now my interest in the innuendo part, whereby, and of course the issue of privilege, on the absolute one and the qualified, whereby you can hear, there's a time you can hear, I'll not mention, but you've heard in the Senate or in Parliament. Somebody can tell you something, you've had a member of Parliament telling the other something until you call a fool in public. And you can't do anything because, of course, that is absolute privilege. And these are matters of public concern. Judicial proceedings. Yeah, these are things you can't claim, you see. But when you have a legal and moral duty, then that's where liability really comes in. So we really need to draw there's a thin line between them, but really the public really needs to know. Because even though we are having this discussion and they're storytelling about it, again, it's an educative platform for the public to know where can you, in which circumstance can you claim this is defamatory, in which circumstance is this just a normal banter, I see. Because if I come in here with my brother, we joke a lot, and I call you, maybe you're a mouse, you can't start complaining because if you ask now to bring out your mouse aspect,
it's not lowering your reputation
for the public. Also, you can't claim that the public, people, so they were seeing me as a human being. Now
they think I'm a mouse.
They think that I'm a mouse, and now when they see me at home, they throw for me beans and rice. And actually, my wife has put for me that and rat. You also finish me because he thinks that I'm a mouse. You see? So we really need to, to make the public have a clear understanding.